Well, why elder care laws should matter, not simply to our senior citizens, but also, and probably more important, to their adult children, is that very often the parents, the senior parents, simply do not have the documents in place. And I'm not talking about just trust or will, but I'm talking about powers of attorney and advanced directives, such as designations of health care surrogate. Because when the parents don't have these in place and there is a accident, a health event, a parent falls and has to go to the hospital, who is going to make the decision if the parent is not able to make those decisions right then? Generally, it would be the person that the parent named in a written document. If it's a power of attorney, that person generally has the authority to make financial decisions, write the checks. On the other hand, the person who is designated as a healthcare surrogate would be the party that deals directly with the doctors, the hospitals, the rehab facilities. And when parents don't name somebody, or just as bad, they name everybody in their family as having equal authority to make these decisions, it's a recipe for disaster. Because then we have all these chiefs, but no Indians. And as a result, when there is a crisis, the problem is compounded because no one has a clear authority to make the ultimate decision. The parent either has named nobody to make those decisions, or they've named everybody and nobody has any greater authority than the other. And as a result, very often the healthcare providers or the banks throw up their hands and they say, well, go to court and have one of you appointed to be the court-appointed guardian for the parent. And most parents don't want that. One, they don't want the stigma of being labeled incapacitated, the result of going through a guardianship. And two, they don't like the expense of having to go through the whole guardianship process. Now, seniors can avoid that by putting on paper the names of those people, whether it's the spouse or some of the children, to make those decisions for them because they trust the people they name. Simply being a spouse or being a child does not alone give someone the authority to make healthcare or financial decisions for an ailing parent. They have to put it in writing. And it often helps out the child because if there are more than one children or a child and a step-parent who are both trying to make decisions, if they can't agree as to what a particular decision must be, then there's a stalemate until someone has to go to court to get them appointed to be a guardian. And that's one of the things we do at the McDonald Law Firm, is not simply just do the document to appoint a child or a spouse as an agent under a power of attorney or a surrogate under a healthcare surrogate designation, but also to go over with the agent or the surrogate the responsibilities that they have now incurred and the kind of information that they need to get before there's a crisis.